9 minutes. That is how long the officer stood at that window, asking questions, applying pressure, using every technique in the training manual to get one cooperative, friendly, completely ordinary answer out of the driver sitting behind that wheel. 9 minutes of questions met with 9 minutes of calm, composed, constitutionally protected silence. And at the end of those 9 minutes, the officer did something that most drivers would never believe was even possible. He walked back to his patrol car, pulled out onto the road and left. No ticket beyond the original stop. No search. No arrest. No extended detention. Nothing. Just taillights disappearing into the night and a driver sitting completely still, completely protected, and completely free to go. This is not a story about a lucky driver. This is not a story about a technicality or a loophole or a legal gray area that only works under specific circumstances. This is a story about one driver who understood something that most people sitting behind a steering wheel in this country have never been taught. Something so fundamental, so documented, and so devastatingly effective that the entire machinery of a fishing trip stops dead in its tracks the moment it is used correctly. By the time this video ends, you are going to know exactly what that driver knew, exactly what they said, exactly what they did not say, and exactly why 9 minutes of silence was the most powerful legal weapon available to anyone sitting in that car. The stop that should have been over in 4 minutes. It started the way most fishing trips start. Small, calculated, designed to look like nothing. The driver was pulled over just after 10 at night on a quiet 2-lane road. The stated reason was a lane change without a signal, a technical violation so minor that in most circumstances it generates a verbal warning and nothing more. The kind of stop that should have been over in 4 minutes, with nothing more than a reminder to use the turn signal next time. But this officer had a different plan. He ran the license, clean record, no warrants, no flags, nothing in the system that gave him any independent legal justification to extend the stop beyond its original mission. Under Rodriguez versus United States, decided by the Supreme Court in 2015, that should have been the end of it. Mission complete. Driver released. Instead, the question started. And this is where the story becomes something every driver in this country needs to hear. Because what happened over the next 9 minutes was not luck. It was not an attitude. It was not a confrontation. It was a precise, calm, legally grounded performance by a driver who had done one thing most drivers never do. They prepared before they ever needed to. What the officer tried and why none of it worked. Here's exactly what happened during those 9 minutes. Every technique the officer deployed, every pressure point they targeted, and exactly why none of it produced a single usable result. Minute 1. The casual opener. The officer returned to the window after running the license and started with the question every driver recognizes immediately. So where are you headed tonight? The driver's response was quiet, polite, and devastatingly simple. Officer, I would prefer not to answer questions. Am I free to go or am I being detained? The officer paused, wrote something down, and tried again. Minutes 2 and 3. The friendly pressure. The officer shifted tone. Conversational, almost warm, explaining that this was just a routine stop, that he simply wanted to make sure everything was fine, that cooperative drivers always made things easier for everyone involved. What the officer was doing, building false rapport to lower the driver's guard, implying that silence was unusual and therefore suspicious, creating social pressure to fill the silence with explanation, framing cooperation as the only reasonable response. The driver said nothing beyond their original statement. Am I free to go or am I being detained? Same words, same tone, same complete absence of the emotional reaction the officer was waiting for. Minutes 4 and 5. The escalation attempt. The officer changed tactics. The tone shifted from friendly to firm. He told the driver that their behavior was unusual, that most people had no problem answering a simple question, that he was going to need the driver to step out of the vehicle. What the driver knew at this moment: unusual behavior is not probable cause for anything. Silence cannot legally be used as evidence of guilt. Stepping out of the vehicle is a lawful instruction under Pennsylvania versus Mims 1977. Complying physically does not mean answering questions. The driver stepped out calmly, hands visible, no sudden movements, no verbal response beyond. Officer, I would like to speak with an attorney before answering any questions. Minutes 6 and 7. The Bluff. Standing outside the vehicle, the officer told the driver he could have a canine unit there in minutes, that the dog would go through the entire vehicle, that things would go much better if the driver simply answered a few questions now rather than waiting. What the driver understood about this bluff: a canine unit takes time to arrive. Under Rodriguez, extending the stop to wait for a dog requires independent, reasonable suspicion. The officer had no independent, reasonable suspicion. The bluff only works if the driver does not know the law behind it. The driver stood quietly, hands visible, eyes forward. I would like to speak with an attorney before answering any questions. Minutes 8 and 9. The collapse. The officer had nothing, no admission, no contradiction, no behavioral indicator strong enough to stand alone in a report, no legal justification to extend the stop further. The driver had given him nothing to work with because the driver had given him nothing at all. The officer asked one final question, a last attempt to crack the composure that had held for 8 solid minutes. You know, this looks really suspicious, right? The driver's response was the same 6 words they had been returning to since minute 1. Am I free to go or am I being detained? At minute 9, the officer told the driver they were free to go, walked back to his patrol car, and drove away. Why silence is the most misunderstood legal tool in America. Most drivers believe silence makes them look guilty. It is one of the most persistent and most damaging myths in the entire space of traffic stop law. And it is a myth that costs innocent drivers enormously every single time it goes unchallenged. Here's what the law actually says about silence at a traffic stop. The Fifth Amendment protects every citizen from being compelled to be a witness against themselves. That protection applies at a traffic stop exactly as it applies in a courtroom. Silence during voluntary questioning cannot be used as evidence of guilt. Invoking the right to remain silent cannot legally be treated as probable cause. Courts have consistently held that exercising a constitutional right cannot be construed as suspicious behavior. Here is what silence actually communicates to an experienced legal eye. The driver understands their rights. The driver is not going to provide the verbal rope needed to hang themselves. The driver has removed the officer's most reliable tool for extending the stop. Any escalation beyond the original violation now requires independent legal justification the officer must produce on their own. Silence is not guilt wearing a mask. Silence is the Fifth Amendment working exactly the way it was designed to work by the people who wrote it into the highest law in this country. The exact framework the driver used. This is the complete system the driver in this story operated from during all 9 minutes of that stop. Every piece of it is legally grounded, constitutionally protected, and immediately usable by any driver in any state in this country. Step 1. Provide the required documents: license, registration, proof of insurance. These are your only legal obligations. Hand them over without commentary. Step 2. When questions begin, say this: Officer, I would prefer not to answer questions. Am I free to go or am I being detained? Step 3. If pressure is applied, return to the same words. Do not elaborate. Do not explain. Do not apologize. The same words carry the same legal weight every single time they are said. Step 4. If asked to exit the vehicle, comply physically. Step out calmly, hands visible, no sudden movements. Compliance with a physical instruction is not consent to questioning. Step 5. If questioning continues outside the vehicle, say this: I would like to speak with an attorney before answering any questions. Then stay silent. Step 6. Never consent to a search. I do not consent to any searches. Said once clearly, and never walked back regardless of the pressure that follows. Step 7. Let the silence sit. Every pause the officer creates is designed to be filled by your nervous explanation. Let it sit. The silence is yours. It is protected. It is working. What 9 minutes actually proved. Here's the lesson inside the story that matters more than any other detail in this video. The officer in this story was not incompetent. He was not poorly trained. He was not having a bad night that made him give up too easily. He was a professional doing his job within a system that gives him enormous power over the average driver. The one thing that system cannot overcome is a driver who knows exactly where their rights begin and exactly where the officer's authority ends. Those two lines, the edge of your rights and the limit of their authority, run parallel to each other across every traffic stop in America. Most drivers never know either line exists. The driver in the story knew both, and that knowledge sitting quietly inside them while 9 minutes of professional pressure was applied from the other side of a car window was the only thing that needed to be there. No confrontation, no anger, no dramatic assertion of rights that escalated the situation. Just a calm, prepared, constitutionally grounded driver who understood that the burden of proof in this country sits on the government and not on the person sitting in that car. 9 minutes. No ticket beyond the original stop. No search, no arrest. Just a driver who knew, and an officer who eventually had no choice but to acknowledge it. Here is what 9 minutes on the side of a quiet road actually teaches every driver watching this video. You are not powerless at a traffic stop. You never were. The power was always there, sitting inside a set of words most drivers have never been handed, and a silence most drivers have never been told was legal. The Constitution did not build those protections for courtrooms alone. It built them for exactly the moment when a driver is sitting alone on a dark road with an officer at their window and no one else around to remind them what they are allowed to say and what they are allowed not to say. That reminder is this video, and now you have it. The next time those lights flash in your mirror, and the questions start, and the pressure builds, and every instinct you have is screaming to just answer and make it easy, you are going to remember a driver who sat quietly for 9 minutes and drove home without a mark on their record. You are going to take one breath, and you are going to say the words, "Am I free to go or am I being detained?" Then you are going to let the silence sit, because the silence is yours. It always was. Share this with every driver you know before you close this app. Someone in your life is heading toward a stop exactly like this one, and they have no idea what they are allowed to do when it arrives. This video is the difference between 9 minutes of panic and 9 minutes of protection. Subscribe because every video on this channel is built around one promise: making sure you are never the driver who did not know. Know your rights like your freedom depends on them. On the right night, on the right road, it absolutely does.